The high school I went to, Clark High School.
Well, it is the best high school in Las Vegas.
I will stipulate to that on the record. Judicial notice. Turns out, which I didn't know, that Judge Kishner and opposing counsel, Colby Williams, also went to West Charleston.
That's because they lived in the rich end of town. I went to Rex Bell Elementary School because I was on the other side of the town. And Mr. Jones, whenever you're ready.
Yes, Your Honor, if I may, in light of our earlier discussion before we started the arguments, Mr. Slade is probably more proficient on some of these more detailed issues on Section 230.
Okay.
So if I may, I'd like to have him address some of those initially, kind of out of order here what we're going to do, but let him go first and then I'll go and address all the others.
I don't have any issue with the order because, as you noted, we just let the folks on behalf of SNAP present what they wanted to present, and you're welcome to present in whatever order you see fit. I am fairly linear, but I'm not quite that linear, so it's okay.
Thank you.
Thank you, Your Honor. I'll do my best to be brief. I just want to hit a couple of points. David Slade for the state. A couple of things about what my colleague said regarding the state of the law on certain issues in Section 230. First, failure to warn is very much alive and well as a claim that is not precluded by Section 230 in the Ninth Circuit, notwithstanding the YOLO case. I'd like to call the court's attention to Doe v. Internet Brands. The site is 824 F3rd 846. It's a case that's discussed in YOLO and distinguished, but it very much holds that a failure to warn claim can survive and withstand Section 230 preemption when the knowledge is had by the online platform and not provided to the world at large. And so I would call the court's attention to that, particularly with regard to our omissions claims in count one. And then similarly, the line of cases is not quite as unbroken as Mr. Blavin would lead the court to believe regarding things like ephemeral content. Most recently, the District of Columbia v. Meta Platforms, Inc. It's a September 9th, 2024 opinion. The site that I have is 2024 super.lexis27.
We don't have Lexis, so
okay.
You can make the Lexis site if you want. I have no way to verify it.
Fair enough. Okay, well, perhaps we can provide the court with it if we haven't already. But in that instance, the District of Columbia challenged ephemeral content as a harmful and addictive design feature, and Meta raised a 230 challenge. The Superior Court held that it was not the claim was not precluded pursuant to Section 230. Similarly, and more similarly and more broadly, Section 230 defenses like those being raised by SNAP have been considered and rejected under analogous circumstances in the Attorney General's or Attorneys General litigations in Tennessee, Utah, New Mexico, and Arkansas. So it's hardly that these cases are outliers. Rather, I would argue they are part of a growing trend.
Now, in your brief, you did highlight cases out of Tennessee, and I believe the other one was Arkansas. Are those the ones that you're referring to?
Yes, Your Honor.
Because you had a footnote in which you included some case law that you indicated, so far every case that's had to deal with this has gone state's way.
Correct.
There's a lot of discussion here today that there, may not have been that be the case, but I did want to review, and I did review those cases. So those are the ones you're referring to. What are the other ones you're referring to?
Yes, Your Honor. There's also an opinion out of Utah, one out of New Mexico, and appreciating that that there must be boundaries between the courts in this building. It is not impossible if I were a betting man to anticipate similar results coming out of Nevada, but I cannot say for certain. So I think that those are the ones that I would call your court's attention to in terms of the trend in this context. Another thing a point that I would like to make, and it relates to Moody, which my colleague brought up in the First Amendment context. Following the Supreme Court's opinion in Moody, there was the Third Circuit opinion, which is quite critical. Anderson v. TikTok, and I don't have anything other than Alexa's site, but it's case number 22-3061 out of the Third Circuit. It's precedential, and it involved a minor who died from following a TikTok challenge. So these are instances where there will be viral videos about people doing incalculably dangerous things, and this minor did that, and I believe passed away. And the estate brought a strict products liability and negligence claim against TikTok for the promotion of the videos and for the use of its algorithm to select that and present that. Now, under previous authority like DIROC, which I will say is actually my case that I argued, so I'm the one that made that bad law, that probably would have been precluded. But what the Third Circuit zeroed in on is an interesting and compelling argument, which is that in light of Moody, when these social media platforms claim that they have a first-party protected speech interest that is afforded First Amendment protections in their platforms, it does not stand to reason that in turn they are the first-party communicants or the first-party creators of the content for purposes of Section 230, and therefore we're not talking about third-party claims, we're talking about first-party content. And it's a very meaningful distinction. I don't know if I'm quoting directly because I was caught a little cold, so I was making notes. But I believe that the quote is, a platform's algorithm that reflects quote-unquote editorial judgments about quote-unquote compiling the third-party speech it wants in the way it wants is the platform's own quote-unquote expressive conduct. And it follows that if these acts are a platform's first-party speech under the First Amendment, then doing so amounts to first-party speech under Section 230 as well. That more or less is page 9 of the order. And then on page 10 of the order, and this is just off of what the Third Circuit published, the recommendation of the blackout challenge was quote-unquote expressive activity, and thus was first-party speech. And Section 230 only immunizes information provided by another. And that's a direct quote that the Third Circuit pulled from Section 230 itself, 47 U.S.C. 230C1. So all of those cases and those authorities and those ways of approaching this, I think, are very important. But another point that I would like to amplify is that absolutely none of the design features that we challenge in this litigation, absolutely none of them hinge on specific content. And if you ask my colleagues on the other side what particular content will be precluded, what third-party content would be precluded if the state were to get every single shred of the relief it seeks, they could not tell you, because there is no specific content that would be precluded from being shared. And there would be no liability stemming from the substance and tenor of that content. Low-friction variable rewards are simply psychological principles baked into the algorithm. The endless scroll, first of all, it's not a traditional publishing feature. No publisher ever created endless content that would consistently bombard the user. I mean, it's not a book, it's not a magazine, it's not the editorial page of the New York Times. Similarly, social manipulation, things like likes, hearts, whatever it is, the counts of the interactions of other people on certain posts. These are actually arguably not third-party content. These are buttons that only the platform enables and creates. And in that regard, I'd say it's also further afield from Section 230 under the roommates.com 9th Circuit opinion that said when you have a platform creating a prescribed list of inputs, that's the platform's speech. It's not really the other parties, because they're telling you can only say or articulate these set number of things. Similarly with ephemeral content, I go back to the case that I cited regarding the District of Columbia, and I presume that it's addressed in other of the recent opinions that we've cited, but very much, again, if we were to get the relief that we seek, in no way, shape, or form would it affect any type of third-party content, which is really what the gravamen of 230 addresses. Push notifications, it's worth pointing out that in the social media MDL opinion that my colleague cited, Judge Gonzalez-Rogers distinguished first-party and third-party push notifications, and actually held that 230 did not preclude claims related to push notifications that the platform itself created. So if it said, hey, there's this game on Snap, and you should come play it, Snap created that. It's not third-party content. So those push notifications are completely outside of the ambit of 230. And I'm being a little non-linear here, but I'd also like to make a point that Your Honor stressed at the beginning of this hearing, which is that we're at a 12B5 motion, and it is, I would suggest, premature to find that 230 immunizes all of the platform features that we are challenging right now, because it's not entirely certain what is wholly third-party content versus wholly first-party content versus a blend of the two. And I think it would be much more appropriate to revisit this on a developed factual record. Again, the social media court indicated that there is this legal distinction, and I think that that's certainly fair, but I would say that that militates in favor of us proceeding now and addressing this down the road. Harmful filters, I'll just very quickly say, the Lemon v. Snap case, it could not be more on point and more clear that these are the products that Snap itself creates. They are first-party content, they are not third-party content. The displaying of geolocation, I think that is the same. And then finally, with regard to the ineffective and misleading parental controls, Mr. Blavin correctly agreed, and I commend him for his candor with the court, that count one really is outside of the ambit of Section 230 because it hinges upon representations that Snap itself has made or omissions. The gravamen of our claim regarding the ineffective and misleading parental controls is that they are misleading, right? That Snap is making these representations that parents have this autonomy and agency in taking care of their children on the platform when in fact they don't. That has nothing to do with third-party content. It simply doesn't. It has to do with what Snap presents as an option to parents that it knows is diluted and adulterated and ultimately ineffective. Those are the principal points that I would like to make regarding Section 230, but I very clearly, the court has thought about this, has questions of its own, and I would welcome the opportunity to address any questions or concerns that the court has.
I'm intrigued by one of the things that you said just now about would this truly be premature, because I had certainly, when I lined things up about what arguments could occur at a motion to dismiss stage and what arguments really don't appear to lend themselves to a motion to dismiss stage, the 230, Section 230 application seemed to fall into that. It could very well lend itself to a motion to dismiss stage. So I'm curious, because just after you made the comment that it would be potentially premature because it isn't 100% clear what's third party, what's first party, or what might be a hybrid, you then focused on certain things, push notification, other things that you said are clearly, at least from perhaps case law that has addressed this prior to us, that this is first party. So I'm a little confused. Is it clear that what you are challenging here is first party, or are you in fact acknowledging that you're challenging some things that are third party, and we need to figure that out? So
that's an excellent question, Your Honor. Let's say I'm trying to have my cake and eat it too, because on the one hand, I do believe that all of this is first party, and under the case law that exists that has dealt very specifically with these types of claims, but then also the emerging case law that is coming out now, really thinking about this much more clearly and much more granularly. I think we win on the motion to dismiss, and I agree that Section 230 is a preemption law. It is a preemption doctrine, so it's meant to be addressed in a lot of ways on a motion to dismiss. But I would submit to you that even though we win, I guess I would say in the alternative, the arguments that I hear being raised by my colleague are that this is all about third-party content. It is nothing but fueled by third-party content. Third-party content, third-party content. We obviously take a very different approach, but I would submit, Your Honor, that if the court has any doubts that we are incorrect, that we kick the can. I mean, there is a synthesis. We could conceivably be both right. Mr. Blavin could be correct that some of the 1, 2, 3, 4, 5, 6, 7 design features that we have, that identified may be a mixture of first and third party content, and that may have 230 implications. I believe that based upon the allegations that we have put forth in the complaint, which must be construed as true, and all inferences drawn in our favor at this stage, make clear that that's not the case. But even if he were right, again, that's the kind of thing that ought to be adjudicated on a fulsome record.
Okay, I appreciate that answer, and I really think that, of my ask, and I think that that answers the question, and I don't have anything to add.
Thank you, Your Honor, for your time.
All right, thank you. Mr. Johnson.
Thank you, Your Honor. And I'm going to pick up there before I get back to sort of the beginning of these issues, if you will.
Yes.
By noting and sort of following up to what Mr. Slade said about the standard by which this court is supposed to analyze this motion. And I know, in fact, last week when we were before you on the preemptive challenge issue, we had a couple of motions to dismiss that were heard before us, and I've been in front of you on other occasions, and I know, as you said, I use the word I'm old school.
Old school.
And I'm older than you, so I'm even older school. But yeah, that's right. And you mentioned it, but I think it's worth mentioning, especially in the context of the point that you just discussed with Mr. Slade. This is Bud Stu versus City of North Las Vegas. This is the controlling precedent this court needs to follow in this case on a 12B5 motion. Dismissal for failure to state a claim is only appropriate if it appears beyond doubt that plaintiff could prove no set of facts, which, if true, would entitle plaintiff to relief. And we look at the Vacation Village versus Hitachi. All factual allegations of the complaint must be accepted as true, and the court must construe the pleadings liberally and draw every fair intendiment in favor of this, in this case, the state, the non-moving party. So in the context of the controlling authority, in light of the dispute, because there's clearly a dispute on what the law is with respect to 230 here as it applies to the factual allegations, it is our contention that this would be inappropriate to dismiss any of these claims under Section 230. So, you know, I don't know, how.
I think that covers it. I obviously do want to make sure we get with you on covering the jurisdiction.
Yes.
And to the extent that you want to highlight from the briefs regarding the specific causes of action.
I will, and that's where actually I was going next. So with respect to personal jurisdiction, and we talked about Tricarchi, I think Judge Kixner, who said that was her case, because we talked about it with her yesterday, she pronounced it Tricarchi, I pronounced it like you did, Tricorici, but anyway, whatever it is. The Nevada case is...
It's like Nevada. To each his own.
Well, I think we would all of us who were born here would prefer to say Nevada.
We would.
We'd be saying Tomato.
But I learned a long time ago to stop crediting, because for a long time you would never say Vegas. You would only say Las Vegas, and you couldn't say Vegas, and that was verboten. And now it's Vegas all the time. So
Yeah.
I'm with you. It's Nevada. But of course, I was being facetious because we have some visitors from out of state who might say it.
Well, in any event, however you pronounce it, that is obviously, as I understand it anyway, the standard for a 12B2 motion on personal jurisdiction, and we need only make a prima facie showing of personal jurisdiction. In reviewing the evidence of personal jurisdiction, the court must accept properly supported proffers as true and resolve all factual disputes in favor of the plaintiff. And I would also point out in the Ford Motor Company case, it came out post Tricorici or Tricarchi. In that case, and I'm kind of jumping ahead of myself a little bit, but the Supreme Court found jurisdiction for Ford Motor Company based on the advertisements Ford Motor Company did that reached into, I think it was Ohio, as I recall, maybe it was Illinois, I can't remember, but in any event, I think the comments in the holding were, Ford's everywhere. It's like if you live in any state, you're going to see the advertisements coming into that state. And it was raised yesterday, and as a counterpoint, well, yeah, but Ford had dealerships there. And actually, no, they didn't. Ford doesn't own the dealership, they're locally owned. So they had no physical presence there, other than their advertising into that community in a way that was found to be satisfy traditional notions of fair play, to be hailed into that state. So,
are you aware of any state where it has been denied specific jurisdiction for SNAP?
I am not, but that doesn't mean that there's not one out there. I have to be honest with the court. I don't know, but certainly.
All right, Mr. Verghese, what are you doing?
I unplugged the laptop. I apologize. That's it.
Don't touch things. When do you not forget?
Apologies.
Just kidding. All right, I think we got it wrapped up. Go ahead.
So.
That's him being, you know, tricky again.
He's got to interrupt Randall.
Trying to throw you off your argument.
That's all right. You did a good job of it. So, you know, again, so if we look at the context of what we're analyzing personal jurisdiction, we're looking at obviously the long-run statute. And we all know that Nevada has the farthest reach of constitutional due process that's allowed under the law for a long-arm statute. And so requires that we show that they, SNAP have sufficient minimum contacts, and that the application of jurisdiction complies with traditional notions of fair play and substantial justice. That's the Arabella case. And then, of course, and this is a critical point. Specific jurisdiction exists where plaintiff's claims arise out of or relate to defendant's contacts with the forum. That's a Bristol Myers U.S. Supreme Court case. So, and that was brought up in personal jurisdiction as it relates to some of the factual allegations we've made in our complaint about SNAP's contacts with Nevada. And as we all we know that the Ninth Circuit test we've talked about with the three-part minimum contacts, that SNAP has purposely availed itself of the privilege of conducting business in Nevada, thus invoking the benefits and protections of its laws. That's our burden. That there must be an affiliation between the forum and the underlying controversy. In other words, an activity or occurrence that takes place in the forum and is therefore subject to state regulation. And that's our burden. But then the burden shifts to if the jurisdiction is reasonable, whether the jurisdiction is reasonable given the concerns of fair play and substantial justice. Well, I want to talk a little bit about the, first of all, the business model of SNAP. In most of these social media companies, it's part of allegations, but I would contend the court can take judicial notice because anybody that's alive today in the modern world knows how these companies, all of them, make their money. They take the personal information, the data from their customers, and they sell it to make advertising revenue. So their whole business model, they don't exist. Financially, they cannot exist unless they infiltrate every aspect of the world, the modern world that they can, even the developing world, to get people onto their platforms so that they can take their data, and they don't steal it per se, because you got to check the box. You got to sign their terms of agreement. Now, what is that, Judge? That's a contract. You are, because I can't get on SNAP if I don't check the box and say I agree. And of course, nobody reads them because they're 20 pages of fine print. So you scroll to the bottom, you check the box. And there's some interesting things in those service agreements as to what you agreed to do for them, including, which we made this allegation in our complaint, and we quoted the service agreement, you agree to give us your data, and we can sell it. We can do what we want with it. Now, and this, I'm jumping ahead of myself a little bit here, but this begs the question of what is their business model and how do they get their customers? Because that's what these consumers are, including the minors of the state. They are their customers who are they getting valuable consideration from. And all one has to do is think about all the hacks and the ransomware people in the world that are happening in these, around the country. What do those ransomware people do? They steal the personal data so they can sell it on the dark web or ransom it back to the people who have it. So it is obviously extremely valuable to even third parties, let alone the party that has it, like SNAP. And so what do we say are the contacts where SNAP has availed itself of the privilege of doing business here, which should make it understand and make it fair to be hailed into the state in litigation? Well, we list them, and these are in the form of declarations. One of the declaration of Danielle Rhoda, a criminal investigator from the AG's office. That's Exhibit 3. And I do want to list these. I know I don't want to bore the court, but I think these are important points.
Go ahead.
These are, and think about these points, Judge. They say, well, so what? We set up a few vending machines here, et cetera, et cetera. They went through the list. Well, I'm going to go through the list with a different take, which this court, presumably, would have to determine to be true for purposes of this motion. Plastering the ghost Snapchat logo on the Luxor Hotel. Well, think about that. They didn't do that as a charitable notion. Why did they put that Snapchat logo up there during CES? They were advertising. They were making their presence known. Presumably, Luxor didn't let them do it out of the goodness of their heart either. Presumably, they had to pay for it. And I would suspect it probably wasn't cheap. But why would you do that? If you spend money, put your logo up somewhere in a giant building, presumably you do that to get customers. That's what advertising is all about. Supplying Snapchat spectacles and vending machines in 2017 CES, both at the Link Promenade and at CES. Advertising on billboards dating back to at least 2017. Now, I'm in a profession, I have to say, I've never done this, and I don't plan to, but there's a lot of billboards in this town with lawyers on them. I don't think those lawyers are putting those billboards up just to say hello to people. The inference that you put your information on a billboard, the clear, unequivocal inference, is you pay money for that because you are trying to sell your product. Hosting Easter egg hunts using Snapchat in 2019, hiding virtual eggs all over the state of Nevada and encouraging users to travel to geolocations to gather the eggs. Now, they posted them all, these geolocation Easter eggs all over the state. Who is going to geolocate those eggs? Most likely, they're going to be Nevada residents. Now, there may be a few tourists in the mix, but they did that in Nevada, and they did it all over the place. Partnering with Verizon and Cirque du Soleil to promote the O Aquatic Show using augmented reality lenses in 2022. Partnering with Live Nation to create 4 new, quote, unquote, lenses for fans at 2022 Electric Daisy Carnival. Electric Daisy Carnival, presumably a lot of those people are on Snap. Why would you do that? Snapchat, because you want to keep those customers and you want to reinforce your relationship with those customers. Done in the state of Nevada. Hosting 3 different booths at the 2024 CES, employing Snapchat technology to simulate crowd involvement during the 2024 Super Bowl in Las Vegas. Now, you're going to do that at the Super Bowl, and you're going to incredibly try to contend that was not to promote their product, including to the people that live in the state of Nevada. And finally, and I think most importantly, hosting high school and college communities on Snapchat targeting Nevada students at UNLV, Nevada State University, and multiple other high schools, including, interestingly enough, the high school I went to, Clark High School.
Well, it is the best high school in Las Vegas.
I will stipulate to that on the record. Judicial notice.
Thank you. I will take judicial notice.
And I would say this has been a fascinating case for me because yesterday, I know I'm going to have a little bit of a digression here, if the court's indulgence. There was, in TikTok, they did a grant to the Wasden Elementary School, which was, when I went to it, the West Charleston Elementary School, and it turns out, which I didn't know, that Judge Kishner and opposing counsel, Colby Williams, also went to West Charleston.
That's because they lived in the rich end of town. I went to Rex Bell Elementary School because I was on the other side of the track.
I remember Rex Bell. But in any event, a little local flavor that I'm sorry I couldn't avoid.
It's all right, it's all good.
So, and I wanna just refer to it for a moment, that, you know, that this, and I have to say this as well. Not that I don't understand the point, but social media companies, remember when Section 47 U.S.C. 230 was passed, it was in the mid-90s, as I recall. Before any of this was happening, nobody could, I think, reasonably imagine where we were going with social media and what the internet turned into. But what's turned out to happen here is social media companies, some of the biggest companies in the entire world, they are using, which is actually a reference made by Justice Thomas in a recent case, they are using 230 as a get out of jail free card. And so everything is defined by them in terms of content, because they know if they can make some connection, as attenuated as it may be, if the Hail Mary pass, we've got to get content. So everything they do, everything. There's not a thing these companies apparently do that is not publishing content. Well, we believe that there are many things that they don't do, including in this case, design features that they create that have nothing to do with the material that is published on their sites. And so in that regard, what has happened is they have allowed certain things to happen because of the addictive qualities of their platforms to have extremely unfortunate and harmful consequences. And I would refer this court specifically to page 24 of our complaint, where in paragraph 62, talking about some of the consequences about these, like Snapchat targeted demographic. These are design features.
Chat right here. Be there with you in 2 seconds. Yes.
And if you just look at the paragraph, starting at line 13.
Yep.
I'm trying to do this in a more truncated way, but the teacher explained that during class, kids were so focused on updating their Snapchat, you would have thought it was crack. They seriously could not keep away from it, even had one girl crawl under her table with her phone. And then look, the next paragraph, 63, the disruptive use of Snapchat in the classroom was no surprise to defendants. In the first post on Snapchat's website, defendants stated it was, quote unquote, thrilled with the disruptions. In quoting Snapchat, quote, to get a better sense of how people were using Snapchat and what we could do to make it better, we reached out to some of our users. We were thrilled to hear that most of them were high school students who were using Snapchat as a new way to pass notes in class. Behind the back photos of teachers and funny faces were sent back and forth throughout the day, end quote. Now, Snap, of course, will take that and say, well, look, they're talking about the notes, it's content. No, they updated their features. Now, we contend that those features are not protected by 230. While they contend, they are. That's a disputed fact, and we believe it's certainly premature, if anything, to dismiss at this stage. But the point is, this is evidence of the continual, systematic, and targeted contacts that Snap has had with this jurisdiction. And is it inappropriate to say a company that is clearly targeting the youth of our state, clearly doing it for a commercial purpose, to gain their personal information so they can sell it to advertisers? Is it really too much to say, well, okay, if you're going to do that, then if you do it in a way that is in violation of the laws of the state of Nevada, you should come here and defend yourself. Is that a violation of traditional notions of fair play and justice? I would submit it's not only not a violation of fair play and substantial justice, it would be the opposite of that if they were to be allowed to continue this practice with, again, if you construe these facts as we've alleged them and shown in declarations to the court, exhibits 3 and 4, and the other, exhibit 4 was from Vanessa Brady, who's at the AG's office as a Steiger Fellow, then we believe we have more than satisfied our obligations or our burden under specific personal jurisdiction. And I would just say that, quoting Keaton versus Hustler, a United States Supreme Court case, and paraphrasing, SNAP has continuously and deliberately exploited Nevada's market for years. And a couple of other points on personal jurisdiction. In South Dakota versus Wayfair, the U.S. Supreme Court, the mere fact that a website can be accessed in a foreign state creates a physical presence for the website owner. Now, they will just try to distinguish that case and say, well, it's a little different facts. But the bottom line is, in that case, having a website going into another state was found, in that case, to be sufficient physical presence for personal jurisdiction. I would also reference McCauley versus Judicial District Court, or even the use of a phone. Calling into the forum can be sufficient if it's a purposeful availment. We have so much more than that in the itemized list we provided through the declarations of Ms. Rhoda and Ms. Brady. I would also point out that they're downloading, these people are downloading these apps in the state of Nevada. And as I said, they're creating a bilateral contract when they check the box. So Snapchat is allowing, they don't have to, they say, if you want to use Snapchat, you got to come to California before you check that box. They clearly know they're targeting Nevada users, including children, and they know that those people are signing off and checking the box. So they're creating actual contracts in the state of Nevada when they send those contracts to be signed by the people on their sites. Further evidence we have is teens using the product. We have this is Exhibit 3, the Rhoda Declaration. A teen in southern Nevada threatening to shoot up his school in Snapchat, a reference. Predatory soliciting of teens in northern Nevada on Snapchat. All of the above can easily satisfy the burden of making out a prima facie case of intentional, continuous, and systematic availment of the privilege of operating the Snapchat program or platform in the state of Nevada. And I don't know if the court has any other questions for me on that issue. I've got more information I can talk to you about. I could other cases that distinguish cases they cite that we think are not. As
I said, I'm going to go back and before making and rendering a final decision, I'm going to go back in light of the oral argument and what's been highlighted here and review the briefings. So I don't, you know, if you want to continue to highlight the briefings, I think the First Amendment, I want to go to the First Amendment, that's why it's in my mind. I think the personal jurisdiction has been well covered for each side's position on that, and the case law that was cited for the various propositions. It's just a matter of the final call on the part of the court. I had First Amendment in mind too because I know when we talked earlier about covering things perhaps slightly different order than they had covered them, I talked about going to the individual claims. But one of the things that I don't want to jump over and give short shrift to is that it was argued that if we're going, the argument was that it's appropriate at the motion to dismiss stage to look at and see if what is being challenged implicates First Amendment and to be sure that we're not allowing that to go forward that way. So I didn't know if you plan to address that, and then I wanted to have you obviously have time to address, to the extent that you feel you need to, you can certainly submit on what's in the briefing on the individual points.
Well, I do. I'm happy to go to the First Amendment, Your Honor. I think that horse has been flayed probably pretty well. So on personal jurisdiction, and if we haven't made our case, I don't know if talking to you for another 10 minutes about it is going to do the job. So. Well,
like I said, I'm not making any decisions today, so I wanted you to all know that. I will be making decisions soon, and anything you feel you want to highlight, as you noted both, I'm taking notes as we go along. I'm gathering my notes. I have my various printouts and case law, and that's the other old school, kill some trees, have some paper. Not ideal, not my favorite thing to do, but in this particular case, I'm making my notes where they're appropriate. So however you want to highlight it, you go right ahead.
Then I will go to First Amendment issues. So I would say at the outset, SNAP again tries to recast the unambiguous language of the state's complaint to conjure up a First Amendment defense. And you know, the gross mischaracterization of our allegations cannot create grounds for dismissal. The harm alleged here has nothing to do with content so much as SNAP would like the court to believe that it does. The alleged harm is the design features embedded in the platform which cause harmful addiction in users and the deceitful practices related to that. So in that regard, there's some cases that they talk about. For example, the Associated Press case and the Meta Platforms case, District of Columbia, they're page 21 of the opposition. Those are cases that we cite that we think are analogous to talk about. Here we talk about design features, not content. We're not trying to, and we say it in the complaint. I mean, again, they say, well, it doesn't matter what you said in the complaint, that you disavow any intent to try to prohibit or limit or censor content. You're still doing that. Well, the allegations we have made specifically and expressly refute that and say, I mean, there are paragraphs in the complaint where we say, I'm trying to think of where they are, I've got them here somewhere. I think it's paragraphs 152, yeah, 152 through 154 of our complaint, where we specifically say we're not doing that. So, you know, they come back and say, well, you're doing it anyway. So, I don't know what you do with that, Your Honor, but they even cite the Turner Broadcasting case and say that that case is favors them or supports their proposition, but I believe that that is distinguishable because that was related to content and not design elements. So we disagree with their interpretation or analysis of that. And in some ways it comes down to as simple as that. We have certain allegations that this court presumably has to accept as true for purposes of this motion. They say, well, we don't care what you say, we say it's something else. You're alleging something else. But beyond that, there's that assuming the First Amendment does apply in some respect, intermediate scrutiny applies to the state's claims in this particular case. And intermediate scrutiny, or under the Turner Broadcasting case, it says, quote, a regulation need not be the least speech restrictive means of advancing the government's interest. Rather, the requirement of narrow tailoring is satisfied as long as the regulation promotes a substantial government interest that would be achieved less effectively absent the regulation. So let's think about that for a moment. Let's just say somehow or other content is, and free speech is implicated here, or First Amendment speech is implicated. That if you consider the intermediate scrutiny, then you have to consider it under the auspices of a regulation that promotes substantial government interest that would be achieved less adequately absent the regulation. So think about that. What is the interest the government has here that we are trying to pursue? The interest is stopping what we consider to be extreme, in some cases, extreme harm to the children of the state of Nevada. I can think of very few, if any, greater interest any state can have in any kind of regulation. So I think we have the highest level of government interest, and our position is, we don't care about your content. Quit making design features that are addicting kids and quit misleading the kids and their parents with respect to how safe your platform is. That, we believe, is at a minimum a state interest that would be appropriate to be allowed to go forward in this case. And then one other thing I have to say, and there's been some cases that have come up here that we didn't see before. Well, we've got one as well, although we actually, I should say that, we did put it in our supplemental authorities as well, and it's the Irwin versus State case. And Irwin versus State essentially holds that commercial speech is not protected. So in reading from the text of the case, in Central Hudson, the U.S. Supreme Court held that commercial speech which concerns unlawful activity or is misleading is not protected by the First Amendment, and that a state may freely regulate it. And citing the U.S. Supreme Court in Irwin versus State is at 563 through 64, 100 Supreme Court at 2350. So even if you want to somehow consider that speech is being implicated here, because it is commercial speech, it is speech with the direct intent for profit, get the consumer to give you up your personal information so you can sell it to advertisers, then again, the First Amendment is not implicated here and would not protect or be grounds for dismissal by Snapchat. Now, if you have any questions about that, Your Honor?
I don't have any questions about that. One of the things that you said in that context, though, about, you know, we're here to help the kids. The state's bringing this in the interest of helping the kids. Correct me if I'm wrong, each of these allegations is about monetary gain for the state, is it not? It talks about civil penalties, it talks about Deceptive Trade Practice Act, penalties. I saw reference to all available remedies, including injunctive relief, but I haven't seen that separately alleged, and I haven't seen that motion. So isn't this about monetary gain? I'm not saying they're not allowed to, but talking about this being so in the interest of the kids, I haven't seen anything yet that would tell me that the outcome here is going to help the kids, but I've seen outcome here alleged and sought that would aid the coffers of the state of Nevada.
I think that's a great point, Judge. I think it's a great point. We actually have a pending motion for preliminary injunction before Judge Kitchener in one of these other cases. But in that case, we had some pre-discovery information that we believe gave us a sufficient grounds to seek a preliminary injunction right away. So as you point out, we reference the potential for injunctive relief. So, but we felt, and I've been doing this long enough to have filed lots of motions for preliminary injunction and restraining orders, had certainly a fair number which were not granted. So as you and I both know, the standard by which the court would analyze a motion for preliminary injunction is quite high. And we are certainly not in a position at this point, we don't believe, to have the factual information that would give the ability to bring such a motion. So
it's not to say that the money could then be, if raised through a successful case, put into use to assist kids, but it just sat a little off for me that I see no evidence of that injunctive relief request in this case, and I see monetary requests. That's why I just wanted to. So that's a very good point, and I would add this, and I'll give you an actual concrete example. In the opioid litigation, which was run by the Attorney General in this state as well as many other states, as I'm sure you're aware, one of the primary uses of the monetary recovery in the opioid cases is to do things like drug addiction treatment and those kind of things. So that money, we believe, and certainly that's the point here, is to be put to good use for people that would be what we would consider to be essentially victims of what we believe to be the harmful effects of these
Yeah, is that okay to answer? There was something else I had thought of, but I want to make sure it's okay to mention.
That's fine.
Yeah, it's public record, so I don't think I wasn't thinking I was out of school, but I might check with the Attorney General's office before I did. Our contingent fee agreement specifically provides multiple areas of injunctive relief that we are going to be seeking for the state in these cases as part of the compensation. So in other words, if we don't achieve certain goals of trying to change some of these things that we think are harmful, we will not be compensated for those things. So it's actually built into this representation as well.
Noticing the clock, if you want to highlight anything from the causes of action, I'm going to give you that opportunity. If there's anything else you want to cover, I'm going to give very brief opportunity for rebuttal to the moving party, but I do want to let you obviously have a chance to highlight, if you wish, about the claims.
Well, so I want to real quick talk about standing, because I know that was a question the court had. So with respect to
somebody's
standing,
hitting the mic. Don't hit the mic, please. It wasn't you, Mr. Jones, but somebody hit the mic. Go ahead.
Standing. So first of all, SNAP cites no authority for the proposition the AG lacks standing to bring these common law claims, but more importantly, the AG is expressly authorized to file suit to protect and secure the interests of the state under NRS 228-170, sub 1. Also, we referenced Bryan versus Judicial District Court. But really, something that I don't think has been focused on is, and by the way, you'll note that the consumer advocate is a reference as counsel in this case as well, the consumer advocate of the state of Nevada, in addition to General Ford. But the consumer advocate may also exercise the power of the Attorney General in areas of consumer protection, including enforcement of Chapter 598, but also the consumer advocate works in the Office of the Attorney General in the Bureau of Consumer Protection, and there are certain statutes there that describe and define what the authority is of the consumer advocate. And so under NRS 228.302, Bureau of Consumer Protection is defined, and 228.304, consumer advocate is defined, and in those in that section of the NRS under 228, specifically 228.308, public interest is defined as means, quote, the interest or rights of the state of Nevada and the residents of the state or a broad class of those residents which arise from the Constitution, court decisions, and statutes of the state of the United States, and from the common law. So the common law is specifically and expressly referenced as one of the powers and authorities that the consumer advocate has in the Attorney General's office to pursue claims on behalf of the state and residents of the state. The consumer advocate has the sole discretion to represent or refrain from representing the public interest in any class of customers in any proceedings under 228.390. Finally, on that point, and this is, again, something we found yesterday, in light of the conversation we had with Judge Kishner yesterday, we did some additional research. And so this is new, but it is, we believe, controlling authority to this court, and that's why we felt we have an obligation to bring it to this court's attention.
Just like Ms. Davidson.
Well, the difference is this is a Nevada Supreme Court case, and I think that at least one of those cases she cited was from somewhere out of state. I can't remember where it was, but it wasn't Nevada.
My point being that as you're preparing to make argument, things come up, and the only thing the court cares about is that it is able to connect to the arguments, connect to the authorities, and be prepared to make its best decision based on all of the available authorities. I've never been one to practice gotcha law, and the fact that something wasn't in a brief or something wasn't here, that's not going to be preclusive to a come up. So I'm just making a connection.
I appreciate that, Your Honor. The case name is State State Power Attorney General versus Moore. It's an old case, 1922, but as far as I know, it's still good law. And in that case, the Attorney General brought suit. And on page 76 of the opinion that I have, it says, quote, we are in accord with his, meaning the Attorney General's, contention that the office of the Attorney General in this state has all of the powers belonging to it at common law in addition to those conferred by statute. So we believe that puts to bed any question about whether or not the Attorney General has the ability to bring claims under common law theories of liability. With respect to the Deceptive Trade Practices Act, I would just refer the court to pages 64 through 69 of our complaint, where we spell out over many paragraphs the specific deceptions and or intentional.
It's titled Public Misrepresentations. Snap leads the public to trust that Snapchat is safe for young users, and then it has subparts.
Yes, Your Honor, that's where, so again, they contend we didn't specify any particular acts of deception. I would disagree and say we spelled it out in over 20 or approximately 20 specific paragraphs where we have done that. Oh, and for the record, I should have done this before. Thank you, Mr. Jane, for pointing this out. State versus Moore is at 46 Nevada or at 207 Pacific 75. We do believe we've satisfied our burden there with respect to unconscionable trade practices under 598.0923 sub 2, sub B, sub 1. If you see page 73 of our complaint, paragraphs 238 through 239, we again spell out why we satisfied the specific requirements of unconscionable trade practices. So unless the court has any questions about that, move on.
I do not.
With respect to product liability, we rely on the Lemon case. If you want me to go through that, I'd be happy to, but they do specifically talk about, in that case, a cause of action for negligent design, that Ninth Circuit case, and a common products liability tort. Negligent design lawsuits treat Snap as a product manufacturer, assuming it negligently designed a product with a defect. Thus, the duty that Snap allegedly violated springs from a distinct capacity as a product designer. So,
and you know, in fairness, because I pushed back a bit with Snap at council that they've highlighted case law. When you focus on Lemon, there's other case law that would be arguably contrary. So, but we understand you want the court to, you know, focus and coincide with that decision.
correct.
But there's other case law as well. So it is something that the court obviously will be fleshing out for itself and what it believes Nevada would be likely to do for that.
And that's the point, is that there's no, unfortunately for all of us, there's no Nevada case that's directly on point, but the analysis of the Lemon court, which is obviously recent, we think it makes a lot of sense. It especially, you know, when you think about what are they doing here? They're selling something. They're selling a platform that people can get on in exchange, and that goes to the consideration argument. And 598.094 defines the sale as, quote, any sale, offer for sale, or attempt to sell any property for any consideration. Any consideration. It doesn't have to be $1. It can be. In fact, one of the analogies that was mentioned by one of my colleagues is, you know, somebody agrees to have sex in exchange for drugs. There's no money changing hands there. But again, there's valuable consideration to people involved. And then finally, referring to the service agreement at paragraph 51 of the complaint, it shows that downloading the Snapchat in exchange for consideration, under paragraph 2 of that agreement, quote, rights you grant us, end quote, which include information about users that Snapchat sells to third-party advertisers. If that is a consideration that I understood it when I went to my first year of law school, I don't know what is. As far as unjust enrichment goes, the enrichment here is not just you get to download an app. It's the enrichment they got, Snap got, from getting your personal information that they monetize.
But how can the state, I mean, I understand your argument about common law and maybe that's where you land on this, but obviously the party seeking to allege unjust enrichment of the other had to be the one that unjustly enriched. How can the state say that they're that person? Because it's one thing to, whether it's the doctrine of parens patriae, or whether it's citation to statute and in some case law, to say the state can do these things on behalf of these people. It's another thing to say that the state, these people, you know, unjustly enrich them. I mean, by your own argument, the money's not, and from their argument too, the money's not coming from the users, the money's coming from the fact that they sell advertising, so.
I would disagree to this extent, Your Honor. What, that information that they're getting from having a customer check that box has value, and we know that for a fact because that's how chat makes its money. So they monetize that information. So they are being enriched by that information. That's, if you'll excuse a sort of metaphor here, that's how they're being enriched, by the information they're taking away, and they're doing it, we believe, under, again, false pretenses or deceptively and harmfully. So they're taking that information without the consumer being fully aware of what they're giving up for that information. And then chat monetizes that information. So there is a monetary component. It's just one step away from the customer. But that doesn't mean that Snap hasn't been enriched and wrongfully or unjustly enriched because of the manner in which they acquired that information, which they then monetized. And I could think of, if I had time to do it, I could probably think of a lot of things about where you had unjust enrichment, where somebody went out and got a bond from somebody that had some value to it. The bond in itself may not have been exchangeable for cash, but somebody took that bond and did something else with it that made it, monetized it. The person that was entitled to that money originally shouldn't get it back. I mean, I don't see how, and again, under parents patriae, that we believe that 598.
These are people who are choosing to be on a platform free of charge. Okay, I understand the allegation that there's data that they then agree to give up to be on that platform, but you know, even in your, whether it's analogy or example that you just gave, this is something that belongs to someone else that they don't intend the other person to keep, that they then are enriched by. How is that what we have here?
Well, again,
These people who voluntarily choose to be, you can say they don't read it, but people know that they're giving up their data.
But if the way they get, that Snap gets the data is by deception, that's the distinction. In other words, so I'll turn the kind of the analogy back around. So I could go cheat somebody out of something of value. Again, take your pick of what's of value. I could trick them into giving me something of value, whether it be money, be property, be even something intangible. But I trick them in giving me that property, whatever it is, and then I turn around and I monetize that, whatever it is that I got from them, or if it already was money.
I just need to be clear what we're talking about here. Which trick are you talking about? I know you talked about what you believe to be, and you highlighted that you have those paragraphs of their deceptive actions, but this is at the point where they're already signed onto the platform, they've already checked the box, because they can't use it without checking the box. So where's the deception that's causing them to give the data over?
So, and this would be something we'd have to prove at trial, that the whole point of this is, would those people check that box? Especially, and again, we're talking about minors here, so whether they even have the capacity to check that box is a big question that we've got to, that's going to be part of this case. But let's say they had parental authority to check the box, and they were over 13. And the parents who checked that box for them and theoretically gave the capacity to allow their child to sign on to this site was misled about what their child was getting themselves into. And had they been aware of, had they known that they were being lied to by Snap as to how safe that platform was, what kind of parental controls really existed that would allow them to really truly monitor their child's behavior. Had they been aware of some of the dangers that their child would be subject to, would they have signed that box? And that's the point here, is if you're...
I'm just concerned we're conflating, I'm signing a box so that I can be on this platform, and I may or may not read the details, but my data will then be used for other things, with, okay, the harm that you're alleging has happened because of the other things. I'm concerned we're conflating those two scenarios in order to reach unjust enrichment when maybe we can't make that connection.
And maybe I'm misunderstanding what you're saying, but what I'm saying is the information on that terms of services, those are deceptive. They don't tell, when you check that box, they're misleading you as to what you're really getting yourself into. That's the point. It's not that I check the box, so now I know I'm giving you this, now you're doing something else. That's part of, we believe, to be part of the deception. If the terms of service don't adequately inform and are intentionally misleading as to what the potential harms are and what the...
I see the distinction. Okay.
So with that, Your Honor, well, if court needs, we don't believe the MTPA requires Rule 9 specificity. We cite Poole versus Nevada Auto, the Supreme Court case, which actually, I'm sorry, was a Court of Appeals case, but it goes through and makes the point that if that was required, then essentially it would be redundant of the fraud statutes that we already have, or common law fraud claims, and it would be superfluous, which this court and this Supreme Court has always found to be, you don't have superfluous statutes or claims. So because it's remedial in nature, you don't need the heightened scrutiny of Rule 9D, or excuse me, Rule 9B. Yeah. And then final point, we do have the conditional counter motions. I would submit to this court, as you might expect, that we think we have fully satisfied all of our obligations on all of the points that were raised in the defendant's motion to dismiss. But to the extent the court feels otherwise, we would ask the court...
I mean, I saw that counter motion mainly be tied to if the court feels it needs more information on jurisdiction. But with the affidavit, as you noted, or declaration, at the moment I can't recall, of Ms. Rhoda and the other information you've gone through, I'm not sure where we would need other information on that point.
It was, as you might imagine, done out of an abundance of caution because we didn't know what you would think or what questions you might have. And to the extent, I think we did, at the last sentence of that paragraph, did say to the extent, I think under Rule the 15, right to amend if the court feels there's any need to amend any portion of our complaint at this point. Thank you, and thank you for indulging me in my time.
Ms. Davidson, are you going to be the final?
Your Honor, may I have 3 minutes and then turn it over to Jonathan?
If you still need to split it, that's fine.
3 minutes.
Y'all can have 12 minutes.
I will be very
Sorry.
brief, Your Honor. I'll even speak from here to save the 30 seconds of walking to the lectern. I just want to address a few things that the state argued to Your Honor. I'm not going to address everything. I would like to note that all of the cases cited by the state, except the new case, are addressed in our reply brief, and I'm not going to repeat what's there given the time. I would like to start with personal jurisdiction, and with respect to personal jurisdiction, I want to make 2 points. Number one, I would respectfully urge the court to read the Ford case, because I think it's really enlightening. In that case, Ford admitted purposeful availment because Ford had flooded the markets in Montana and Minnesota with ads, with dealerships, and I understand the point that the dealerships are independent, but Ford provides services and support and warranty service and all sorts of things at the dealerships. Ford had flooded, as we all know from our own lives of seeing car ads. There's no comparison between that and having a sign on a hotel that's having a convention.
Can I ask you the same question that I asked Mr. Jones, which is, are you aware of any jurisdictions where SNAP was found to not have specific jurisdiction?
Where SNAP was found not to have specific jurisdiction, yes, Your Honor, we identified them in our.
Is that how I asked the question? I feel like I'm asking the question incorrectly again.
Are you asking a reverse question?
I'm somewhat trying to ask the reverse question. I'm not sure I'm doing it artfully. It has been a long day. I know that you have pointed to case law and you have talked about situations where you believe that there's just not the contacts, etc. But I don't know that I asked the question. I don't know that you pointed to cases where a jurisdiction specifically analyzed that jurisdiction's contacts with SNAP and that were maybe analogous to those here and found that they did not meet this specific jurisdiction.
Yes, Your Honor, I just checked with Mr. Blavin, who indicated that there was a case in New Mexico where SNAP did not prevail on his personal jurisdiction.
Okay.
Not cited by plaintiffs.
It's not cited by plaintiffs,
the
there isn't a reasoned decision or order on it, but I am aware of that one case.
Were SNAP did not, or the state did not?
It was a private plaintiff case against SNAP. The personal jurisdiction argument was asserted. The judge did not issue a reasoned decision on that, but denied the motion to dismiss on personal jurisdiction grounds.
I think I'm asking the opposite of that question, but go ahead, of that answer. I think the question I'm asking would be the opposite of that answer, but let's let it go. Go ahead,
Okay,
just however you, I don't want to take your
We
time.
did cite in our brief and on slide 4, Zienchik versus SNAP in Western District of Pennsylvania, where SNAP prevailed on its personal injury argument, if that's what you were asking.
That's what I was trying to ask.
Your Honor, I also wanted to address the comment about adding your school. So just to be clear, that's something where if you're on Snapchat, you can click on a place where you can add your school and then you connect with other people from your school. That's not SNAP creating, Clark High School, et cetera, types of groups. Those are just, as you know, Your Honor said you've got familiarity with social media and other platforms. People join groups, just like they would a listserv, a neighborhood listserv. This is an opportunity for people to identify, hey, I went to this school, and then they can chat with each other. But it applies to any school. You could list your school in any state or any part of the country. Finally, Your Honor, with respect to personal jurisdiction, I do want to point out that the Wayfair case had to do with sales tax. It had nothing to do with personal jurisdiction. Your Honor, I very briefly went online and tried to pull this state AG versus Moore case from 1922, and I do want to point out to Your Honor that while I have not read it in full depth, this is a case where a state AG tried to get involved in a divorce case, and the court says we are in accord with his contention that the Office of Attorney General in this state has all the powers belonging to it at common law. That doesn't mean it has all powers at common law. And then it says, we are of the opinion that the Attorney General had no power to intervene in the divorce suit. So to say that this case is binding authority that requires the court to find that the state AG has common law authority here is not clear to me how you get put there from this case. I do confess that I only read it very briefly, but that is my quick impression of it. Finally, Your Honor, I do want to point out that the state has referred vaguely to various policy principles in the Nevada revised statutes, but there is nowhere that provides authority for this kind of lawsuit. And if the statutes intended to provide authority for this kind of lawsuit, they would have, because there is authority for all sorts of other things. If you look at NRS 228.380, it lists the consumer's advocate may exercise the power of the Attorney General to enforce the following chapters. It doesn't say to enforce common law principles of unjust enrichment, product liability, or negligence. And with that, I'm going to turn it over to Mr. Blavin.
Thank you.
He has a lot of notes, but he's going to speak quickly.
I will.
No, he's not going to speak.
I'm not going to speak quickly, but I will be
He's
very
going to speak
efficient. Concise, yes, Your Honor. Thank you. I'll start, Your Honor, with the point of whether it's proper to decide the question of 230 immunity on the pleadings. What I would note is every single case that we've cited, Your Honor, all of the Ninth Circuit authorities, other courts of appeal authorities, the JCCP court, the federal MDL court, all of those were decided on the pleadings. And the reason why that is because As the Ninth Circuit, for example, noted in the Fair Housing Council versus Roommates case cited in our papers at page 10 of the opening motion, it's 521 F3rd 1157, that Section 230 is an immunity statute. It's an immunity from suit statute. And courts have held that it is proper to determine the scope and application of immunity at the earliest possible stage of the litigation, because if you wait until later stages, you're incurring the cost of litigation, discovery, and immunity at that point is effectively lost. So that's why all of these courts have decided these questions on the pleadings, and that would be proper here. I heard my colleague say, well, we have a dispute here over how the law applies to particular factual allegations, and that was said a couple of times. That is a question of law. The question is, you look at the allegations and you say, do those allegations fall within the scope of Section 230 immunity? And again, the court's considering effectively the same claims in the MDL court. Judge Gonzalez-Rogers, Judge Kuhl in the recent motion to strike order have done exactly that. There isn't a dispute over facts. There's a question of whether the law, as it's been construed by the Ninth Circuit, the overwhelming majority of federal courts, and state courts, bar the claims at issue here. And the court can and should do that on the pleadings. I would also note that my colleagues on the other side noted that, well, Justice Thomas, in a dissent from a grant of cert, recently said that immunity shouldn't be construed this broadly because everything the platforms do in some way relates to publishing activity. I mean, it's interesting that that is cited because that is a denial of cert, because the Fifth Circuit held in that very case that Snapchat was immune from liability for claims similar to those asserted here, including with respect to ephemerality. This is the Doe versus Snap case that we cite in our papers. It went up to the Fifth Circuit. The plaintiffs there sought cert, and that was denied. So the Supreme Court refused to review the Fifth Circuit's decision there. And Justice Thomas is essentially complaining about the fact that the scope of the law, as interpreted by the courts that we have cited to Your Honor, is too broad. And he disagrees with it. Obviously, a denial of a cert statement is not authority. If anything, reflects that the authority is going the other way here. The state also said that they asserted a disavowal, that their claims depend on publishing third-party content. Obviously, a disavowal in and of itself is not sufficient. You need to look at the underlying allegations, and that's what we've done today, Your Honor, with agreed it was a painstaking process of going through those particular allegations and everything listed in slide 6, but that shows that if you look to their allegations and you go past the conclusory disavowal, their claims are, in fact, predicated on Snap's decisions and determinations as to how it publishes third-party content, and that's exactly what the courts have said is conduct that is immune by Section 230. Very briefly, Your Honor, the state noted that they cited the case from Tennessee involving the state AGs. They cited some other AGs cases. As we noted in our papers, just to be clear, those are cases that don't have a lot of reasoning. One of the cases, the Tennessee case, relied on the JCCP court's initial demurrer order, but then the JCCP court initiated another order on a motion to strike, which contained much of the authority we're relying today, saying that those claims are barred under 230. So the Tennessee court relied on an initial order from the JCCP court. The subsequent order strongly supports our motion today. Briefly, Your Honor, with respect to the failure to warn claim, counsel noted that the Internet Brands case from the Ninth Circuit supported the fact that you could have a failure to warn claim. I would request that Your Honor, urge Your Honor to take a look at the discussion of Internet Brands in the Bride versus YOLO case, which is the most recent decision that we cited. There, the Ninth Circuit made absolutely clear that Internet Brands was distinguishable because there we reasoned that the plaintiff sought to hold defendant liable under a traditional tort theory, the duty to warn, which had no bearing on Model Mayhem's decision to publish any information on its site. So the Ninth Circuit went to pains to distinguish the prior Internet Brands decision, said, in that case, the knowledge that the website gained about potential predators who would be trying to contact women had nothing to do with anything published on the website or any publishing features. And the Ninth Circuit said that case simply didn't have to do with publishing, and it's distinguishable. And again, in the most recent decision from the Ninth Circuit, the Bride case made absolutely clear if you're trying to challenge a protected publishing feature under the guise of a failure to warn claim, and again, I said this, Your Honor, but I want to make it clear because they've said, well, we've conceded somehow that omissions would not be barred by 230, and that's absolutely not the case. An omission claim is no different than a failure to warn claim. The Ninth Circuit's
So the only thing I heard you say talk about was intentional.
Exactly, for intentional affirmative statements. That's what I made clear. That's correct, Your Honor. In addition, counsel referenced the recent Anderson case from the Third Circuit. We did actually address that case in our supplemental authority notice. It was footnote 1 on page 3. This is the one that we submitted regarding the Bride case and the Bonta case. Because we had cited the district court decision, I wanted to make clear to Your Honor that yes, we are aware that the Third Circuit reversed that district court decision. Now, to be clear, the Third Circuit itself recognized in its order that its decision departed from the views of other circuits and noted the 1st, 2nd, 4th, 5th, 6th, 8th, 9th, and DC circuits as being contrary to the analysis in the court's decision. Counsel effectively stated that we understand that under the 9th Circuit's decision in Dyroff, we have some problems and we can't pursue our claims if that were to be the law that Your Honor would adopt, at least with respect to algorithmic content recommendations. And what I would note, Your Honor, is not only do you have the vast majority of circuits disagreeing with the Third Circuit in that case, but you have the Ninth Circuit, which of course is the federal circuit that the state of Nevada falls within. Now, while the Ninth Circuit's decision is not binding on Your Honor, I think Your Honor would recognize that to have the Ninth Circuit, the Federal Court of Appeals, interpreting a federal statute, that has unique persuasive power, particularly when Nevada falls within the Ninth Circuit. And again, you have many, many other circuits which have come to the contrary conclusion. And just as an example of this, in the Force versus Facebook case from the Second Circuit, which I cited to Your Honor earlier, the Second Circuit considered this exact argument, which really underlies all of the plaintiff's claims, that these are decisions made by the platforms with respect to how they publish third-party content, what features they have in, and that somehow converts you into a speaker. You're the content developer, and therefore 230 doesn't apply. This is what the Second Circuit said. The plaintiffs assert that Facebook algorithms suggest third-party content to users based on what Facebook believes will cause the user to use Facebook as much as possible. This is their addiction theory, which they're asserting right now. And that Facebook intends to influence consumers' responses to that content. The Second Circuit said, this does not describe anything more than Facebook vigorously fulfilling its role as a publisher. Plaintiff's suggestion that publishers must have no role in organizing or distributing third-party content in order to avoid developing that content is both ungrounded in the text of Section 230 and contrary to its purpose. This is the exact argument that we heard from the state, the Second Circuit, the Ninth Circuit, multiple circuits have rejected it, as did the MDL and JCCP courts.
Well, if they give the Second Circuit the last word, it's after 5 o'clock and I have to call it the last.
Of course, thank you, Your Honor.
I sincerely appreciate everybody's efforts in the briefing, in the oral argument today. It's imperative that we have all the information available to us. Ample information has been provided here. I will circle back and conclude with this as a motion to dismiss. We are going to apply the appropriate standard and we are going to make that determination. And I would like to put it on for next Tuesday. I don't see why we need any longer time than that for us to do that. I don't feel that either side should be compelled, with the few additional authorities that sort of came in last minute, to have to be contrary arguing to them in brief. But if you want to file something about the newly asserted, because there were some on each side, case law, you can file that by Friday. But I don't encourage you to do it. I don't think it's necessary, but if you choose to do it, so be it by Friday. Otherwise, we will be back here next Tuesday. I'd like to offset it at 10:30 so we can try to get through the bulk of our calendar and then be able to have a minute to do our best to articulate our decision. And then oftentimes what happens is people want clarification. I think that's a code word for I want to try to make more record and or muddy the record depending on which side I fall on the decision. But at the end of the day, we want to leave room for that as well. So it'll be next Tuesday at 10:30. My clerk will make it official right now.
October 1st, 10:30.
We'll see you then.
Thank you, Your Honor. Thank you for your time and your staff too.